I will now call Kelly Donovan. Is Kelly Donovan here? I believe that's a virtual presenter. Kelly, you have 10 minutes to make your presentation, after which there will be a 5-minute question period. I apologize in advance if I interrupt you at the end. If you do need a moment of extra time, that may be afforded, but if you could aim for 10 minutes, that's how we're trying to do things. But Kelly, you have the floor and our attention. Please go ahead.
Thank you. Well, up until 2017, I was a police officer with the Waterloo Regional Police Service. Starting in 2015, I began to witness subjective enforcement of our laws when criminal allegations, domestic in nature, were brought against a member of the police service. At times, they weren't even investigated. I do not believe that police have the right under common law discretion to choose when to and when not to charge or even investigate based on personal motive. It still did not sit well with me, and I wanted to do something about it. My union president told me that's just the way policing was, and that I would never be able to change it. Our laws in Ontario actually prohibited me from complaining formally about what I perceived to be corrupt practices and inadequate policies. The only thing I could lawfully do at the time, which was in 2016, was speak at a police services board meeting, much like this hearing here today. I expressed to the board what I had witnessed and why I believed that my chief of police, Mr. Brian Larkin, was abusing his authority when making decisions involving criminal allegations brought against our own members. Following this disclosure, the chief was allowed to put me under investigation for misconduct. I was removed from my position as a use of force instructor, and I was ordered to cease communicating with members of the board. I was gagged. After 14 months and several failed attempts to have an oversight body intervene in the retaliation I was facing, I chose to resign. While negotiating my resignation, I made it clear that I would not agree to an NDA. I made it very clear that I would not sign a contract that prohibited me from speaking about my experiences. If they required the NDA, I would simply have remained employed, collecting my $100,000 a year salary with full benefits and pension. But they did agree. I also required that a release be signed by them so that they could not harm me anymore. At this point, I had researched how prevalent whistleblower retaliation was in policing, and I knew they had access to many retaliation tools. Upon resignation, I traveled across Canada sharing my story to encourage lawmakers to enact whistleblower protection laws so that the next person who reports what they believed to be unethical leadership does not face reprisal at the hands of the very person they are reporting. In 2018, I spoke at the Ontario Legislature, and because of my testimony, police officers are now legally permitted to file complaints and are even afforded protection from reprisal. I have made a difference. Yet, I'm not safe. Despite my refusal to sign an NDA, and despite the release that was signed by the Waterloo Regional Police, only 6 months after my resignation, the retaliation began again. Confidential details of my resignation agreement were exposed, and the service filed an appeal of my workplace injury claim for PTSD to have my benefits revoked. They wanted to take away whatever I had left, despite the legal contract they signed. This started a litigation battle that is now entering its 5th year. The police service went on to file a contravention of settlement application against me at the Ontario Human Rights Tribunal, alleging that all of my public speaking is in violation of my resignation agreement, yet they acknowledge there is no NDA. As of August 2021, which is over a year ago, the police service had spent over $500,000 on their lawyer to try to achieve my silence, and they continue to spend. We must stop the silencing of victims of harassment and discrimination. That is extremely important, and it is a wonderful first step having all members of the Legislative Assembly agree on that priority. I hope that my story will provide insight into the misuse of NDAs and the abuse of individuals who refuse to sign them. If you believe what happened to me was wrong, then it is imperative that Bill 225 be revised. Telling a victim of harassment or discrimination that they can't talk about what happened to them for the sole intent of protecting the offender is wrong. What I feel is most important at this stage is that we all understand that NDAs are being used to cover up so much more: abuses of power, criminal acts, and all forms of corrupt behavior. If the behavior that is being buried in an NDA does not fit the definitions of harassment or discrimination, the Non-Disclosure Agreements Act would not protect the complainant. To explain that further, in my case, what I initially alleged was that the police service was choosing when to and when not to investigate and charge their members accused of domestic abuse, depending on the officer. I was immediately disciplined, taken out of my job, and gagged. The police service hired a lawyer to say in her report that I was not harassed or discriminated against in the way I was treated following my disclosure. When I chose to resign, the police service did not want me to voice those allegations again. They wanted me to sign an NDA. But I was not a victim. I was a witness to what I believed was corrupt behavior. But they didn't want me to be able to talk about it. And I knew this was wrong, so I refused to sign the NDA. It's my belief that even if I had signed the NDA, the proposed act would not protect me, since the best way to describe the way I was treated was retaliation, not harassment or discrimination. And the retaliation I faced was not for reporting harassment or discrimination. It was for reporting what I perceived to be corrupt practices. I firmly believe that Section 3 Sub 1 of the proposed act should read that if a provision of a non-disclosure agreement prohibits or restricts a complainant from disclosing information concerning a violation or alleged violation of any federal or provincial act, the provision is invalid and unenforceable. If you knew the types of offenses alleged to have been committed by high-ranking public officers who are now protected thanks to NDAs, you would support this recommendation. The Human Rights Code of Manitoba prohibits harassment, discrimination, as well as reprisal. I feel at the very least, reprisal must be included in the Act. But if we look at similar Canadian laws, we already protect employees in Section 425.1 of the Criminal Code of Canada. Under Section 425.1, if an employee witnesses or believes they witnessed an offense being committed by the employer, or an officer or employee of the employer cannot take any measure against the employee to try to stop them from providing information to a person whose duties include the enforcement of federal or provincial law, or with the intent to retaliate against the employee because they did provide information to law enforcement. We understand the need to ensure that employees feel safe reporting alleged violations of law, but we currently do nothing to stop those employers from having the employees sign an NDA to conceal the very same conduct. So in a way, an NDA is already unlawful in Canada, but obviously this law isn't helping Canadians. Based on Criminal Code Section 425.1, if an employer had an employee sign an NDA to conceal a violation of law, which would include the Human Rights Code, meaning harassment and discrimination, that could be seen as a criminal offense committed by the employer. My resignation agreement states that I'm not able to file any complaints against the police service for what they did to me prior to my resignation. In my opinion, that violates the criminal code. It's time that Canadian lawmakers understand that it's the abusers themselves who have been empowered to silence their own victims. This is why we need laws prohibiting NDAs, and this is why those laws must be robust. A person who witnesses someone in a powerful position of authority committing an egregious act is not really given a choice. They can either sign the NDA to protect the powerful person, or they will face a lifetime of retaliation. That's because without an NDA, the person can talk. And if they speak the truth, they can't be stopped. If their truth-telling threatens the powerful person will do just about anything to shut them up. That is the blunt reality. And if you don't believe me, you can tune into my next Human Rights Tribunal of Ontario hearing to watch the retaliation in real time. It's not only the silencing of victims of harassment and discrimination that must be stopped. There are men and women across Canada who witness egregious abuses of power and criminal acts committed by public officers whose only hope at escaping a lifetime of retaliation is to sign an NDA. I'm living proof of that. I've now faced retaliation by them longer than I was even employed by them, and they have spent over $500,000 to try to achieve my silence. To conclude, I applaud all members of the Legislative Assembly for their commitment to a higher ethical standard. You are leaps and bounds ahead of other provinces in the country. I thank you on behalf of those who don't feel safe being here to speak, And I thank you on behalf of the next generation who will be better protected as a result of this act. Understanding that many very well educated and experienced people worked on Bill 225 to get it to where it is today, I very humbly make my suggestion to you based on my experience only. And my suggestion is to revise Section 3, Sub 1 to read that if a provision of a non-disclosure agreement prohibits or restricts a complainant from disclosing information concerning a violation or alleged violation of any federal or provincial act, the provision is invalid and unenforceable. This change would protect victims of harassment and discrimination, but also so many other men and women across Manitoba. At the very least, I would suggest including reprisal along with harassment and discrimination.
Ms.
But I would
Donovan,
define.
sorry, the rules require that I tell you the time has ended. Leave has been requested. Is there leave? Yeah. Leave has been granted. Please complete your presentation. You have, I'll give you 2 minutes to do so.
Yeah, I'll be very quick. All I would do is I would define reprisal to be very broad and include any conduct resulting from a person's attempts to follow any law. And all I wanted to do was thank you for providing me the opportunity to speak, and I welcome any questions or comments that you have.
Thank you for your presentation, Ms. Donovan. We'll now have some questions. I see 3. We'll start with Mr. Lamont. Mr. Lamont, please go ahead.
Yes, I thank you very, very much, both for your courage and your integrity and exactly what you've done. It's absolutely inspiring. And I would be more than happy to strengthen the bill in any way we can to protect people against reprisals. Whether we review it or however that will proceed, I want to thank you very, very much, both for the public stand you've taken and the work you've done. And I hope we can honor your work.
Ms. Donovan, if you wish to respond, you may do so.
No, just to say thank you, Minister Lamont. Thank you very much.
Just to clarify, it is Mr. Lamont, but
Yes.
Ms. Naylor, please go ahead with your question.
Thank you so much, Ms. Donovan. You have again presented us, like as so many speakers have tonight, like another way in which NDAs have been used to silence people who need to be able to speak. So thank you for that. Thank you for your recommendations and for drawing our attention to where there may be a gap or other gaps in this bill as the way that it's written so far. I think that's really important, really crucial for this committee process that allows us to hear that feedback. And thank you so much for taking your time to tell your story here tonight.
Ms. Donovan, if you wish to respond, you may do so.
Yes, if I may, because she reminded me of something. I think what's important to keep in mind is that, our system of laws have deterrence by way of punishment, but when it comes to a lot of the acts that are suppressed in an NDA, just having a law prohibiting NDAs will create an entirely new culture of accountability. So it's not about us needing laws to punish the people causing these harms. Just knowing that this information cannot be suppressed forever in a legal agreement might be just enough to change behaviors within workplaces, within corporations, whatever it is. So I think it's important, you reminded me of that when you were talking about the purpose of it was just that, you're taking a huge step by implementing this legislation, but in doing so, you change the culture. And everyone talks about how difficult it is to change workplace cultures, but just knowing that that's not a possibility anymore is huge and protects people just with the mere risk of not being able to do that anymore. People's behaviors will change, and that's why it's so important that this act pass. Minister
Gertson.
Thank you, Ms. Donovan, for your presentation, sharing your experience, and most importantly, for sharing your suggestions. And I would ask, and I know you're busy, and I can tell you're busy, but I can also tell you're probably an advocate without, you probably get tired, but you probably never cease. And there is going to be an opportunity to make some presentations and some suggestions to the Manitoba Law Reform Commission. Their website is manitobalaw.reformcommission.ca. ManitobaLawReform.ca, and they're undertaking an investigation on non-disclosure agreements. And they're going to be putting out a consultation paper in the next few weeks. And I think that your advice in a consultation paper, or maybe as a designated stakeholder or expert, would be very valuable for them to hear. So I just wanted to leave that with you, and if you're able to reach out to them, I know they would appreciate it.
Ms. Donovan, if you would like to respond, you may.
Yes, thank you very much. I will definitely look into that.
Are there any other questions? Hearing none. Ms. Donovan, we thank you for your presentation and your time this evening.